Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, here today with another mini advertising law lesson. Today's law lesson, the biggest myths in digital marketing and how to combat them. Myth number one, everything you find on the internet is not public domain. Right-clicking might be possible, but it doesn't mean that you should. It's one thing to right-click and use a photo you find on the internet for a collage for your mom for Mother's Day. It's quite another thing to use that in major advertising. And Virgin Mobile found this out when it used an image off Flickr under a Creative Commons license, but then was sued by this girl's parents when it turned out that the guy who uploaded the photo did not have permission of the individual for her to be used in Virgin Mobile's advertising. Myth number two, people say, we'll change it 30% and it no longer will be infringement. Well, it's very dangerous to start with somebody else's creative work and then move on from there. And why is that? Well, the person who created it is going to look at it extremely carefully, and there is no set percentage of how much you have to change something before it's no longer in infringement. The true test is, have you created an entirely new work with an entirely new aesthetic? And now don't shoot me for saying this, but is our job as marketers really just to troll YouTube and recirculate ideas that have been popular before? Myth number three, we'll pull it if we get caught. Well, that always sounds like a good plan, but it's not necessarily. First of all, even if you pull it, you are going to have to spend a lot of money on lawyers like me that nobody is happy with. Number two, if you pull it, you don't have an ad to run, and your client could be extremely upset about that. Number three, you've got the problem that you spent all that money on that ad that you can't use, and now you have to spend a lot of money on a new ad to fill that place. Who's responsible for that cost becomes a very tricky issue. Myth number four, well, they do it on Saturday Night Live, so why can't we do it? Well, you have to understand, things like Saturday Night Live are protected heavily under the First Amendment, while commercial advertising is subject to a lot less protection under that same First Amendment. So what you see in TVs, movies, plays, books is not the same thing that you can do in your advertising. Myth number five, we're in the clear because the networks approved it, the client approved it, and our lawyers approved it. Well, television network clearance is not legal clearance. Just because the networks have said it's okay to run on their network and that it's okay under their broadcast standards does not mean that your ad is legal. Secondly, just because the client approved it does not mean that they won't come back after you later if there's a problem and tell you you're responsible for the claim. The 500-pound gorilla sits wherever they want, and if your contract with your client says that you are ultimately responsible for any legal claims, it's highly doubtful they'll take responsibility. And then, of course, just because your lawyer allowed it to go through does not mean there is no risk. All of this is certain levels of risk, and something that's low risk doesn't mean no risk. Tips. Run it by your lawyers first. You don't want to get in a situation where you sold it to the client and then you show it to the lawyers and the lawyers tell you that it can't be done. It's an embarrassing and upsetting situation. If you bring it to the lawyers first, they can help you with a solve. And that's what we do here, is we don't say no. We try to find a creative solution to getting your work done. Number two, now you want to make sure that when you are creating something that is based on the same idea as somebody else's, that the unique elements, expressive elements of your work are very different from the others. You see here two photos. One was a Kate Spade ad and one was done by a photographer. The photographer claimed that the photo in the advertisement was an infringement of his photograph. But Kate Spade argued its ad was not an infringement because all of the expressive elements were different. The shoes, the bag, the floor, the color, the angle, all of those things were different. Tip number three, consider ignoring everything I just said, because copying somebody's idea is very dangerous and anyone can sue anyone for anything for any amount. So, if you're using the same idea as somebody else, even if your expression is very different, if they have a lot to protect, you might find yourself at the end of a claim. And even if you're right, nobody's going to care about that when the legal bill comes rolling in. Tip number four, Don't reference your points of inspiration in your scripts. Why? Well, those files are going to come back to haunt you. If you are ever sued, you're going to have to turn over those files. And the claim that you didn't intend to infringe is going to be very hard to believe when it's written down there. Tip number 5, when all else fails, ask for permission. But just remember, if you go to them and they say no, you really should either move on or change the concept rather substantially. Getting permission is great if you can do it, but it does have inherent risks. You're on their timeline, and if it takes them a month to get back to you, there's nothing you can do about it. You're on their financial budget. You might think it's only worth $500, but if they ask for $1 million, there's not much you can do about it. And you're subject to their creative whims. If they don't like the way that their brand is being portrayed in your ad, well, there's not much you can do about it. And that's it for our mini advertising law lesson for today. Just remember to follow me on Twitter at Heidelberger, or more mini law lessons are on YouTube at youtube.com/Brian Heidelberger. And in the meantime, let's be careful out there.